One mistake, and you're a felon. Open carry in Florida. Cars sound simple. You've got the right, so you're good to go, right? Wrong. One wrong turn, one visible holster, or one misunderstanding, and you're not just pulled over. You're booked, charged, and possibly facing federal prison. Florida law may have opened the door to carrying, but it's surrounded by invisible traps that even seasoned gun owners are walking into every day. Today, we're breaking down 3 legal traps that could destroy your record, your gun rights, and your freedom, and how to avoid them. Subscribe now, because knowledge isn't just power anymore, it's protection. Chapter 1. The School Zone Danger. Open carry in your car might feel like a right you've earned, but drive past a school and everything changes instantly. Federal and state laws both treat school zones as zero-tolerance areas, and you might break the law without even realizing it. Federal law, Section 922Q of Title 18 of the United States Code, prohibits firearm possession within 1,000 feet of any school zone unless you're licensed by that state. Florida law adds restrictions, making it a felony to carry near schools, school-sponsored events, or even on private property adjacent to school zones. Gun-free zones include public and private K-12 schools, school buses, and even daycare facilities. Even if your gun is legal and unloaded, if it's visible near a school, you could face arrest and lose your rights permanently. These laws have no grace period, no exceptions for travel routes, and no room for error. You don't even have to step out of your car. Just driving past a school with a holstered firearm in full view could trigger felony charges. Police don't need intent, just location and visibility. Chapter 2. Underage carry equals criminal charges. Florida law is crystal clear. If you're under 21, your right to carry in a vehicle is extremely limited. Even if you legally own the firearm, open or concealed carry inside a vehicle is still illegal for those under the age of 21. Florida State 790.25 restricts handgun access and transport for anyone under 21 unless securely encased and not readily accessible. Carrying on the seat, center console, or anywhere within immediate reach violates state law. Having a gun in your glove box or waistband, even for self-defense, could lead to misdemeanor or felony charges. No self-defense argument can override statutory carry age restrictions. Many younger gun owners think that if they're allowed to purchase or possess a gun, they're automatically allowed to carry it. But under Florida law, there's a legal wall between ownership and in-vehicle carry that punishes ignorance with jail time. Chapter 3. Your car isn't always your castle. You might think that because it's your vehicle, you control what happens inside, but the law sees it differently, especially on private property. Florida law does allow lawful storage of firearms in vehicles, but this only protects concealed, securely encased weapons. Businesses or property owners can demand that firearms not be visible on their premises, even if it's your own car. If you refuse to comply or fail to leave when asked, you could be charged with armed trespass. Visible firearms in parking lots have triggered 911 calls and arrests, even when no law was technically broken. This trap affects anyone parking at shopping centers, churches, workplaces, or even apartment complexes. Even though your car is yours, your surroundings might not be, and Florida law allows property rights to override your carry rights in certain cases. Chapter 4. Accidental display can equal a crime. You don't have to threaten anyone. You don't even need to say a word. If someone sees your gun in your vehicle and feels afraid, that's often enough for a criminal charge. Florida State 790.053 prohibits open carry in most public spaces, and unclear visibility can violate this rule. A gun on your seat, partially covered by a jacket, can still be considered visible if any part of it is in plain view. If a passerby calls the police claiming suspicious behavior, law enforcement is obligated to investigate. Officers may interpret even brief visibility or movement as brandishing or improper exhibition. There have been cases where simply reaching into a glove box near a holstered firearm, while stopped by police, has led to firearms charges. What matters is how your actions are perceived, not your intent. And in court, perception often beats reality. Chapter 5. Your permit might not save you. Even if you're a licensed concealed carry holder in Florida, that permit doesn't shield you from all risks, especially when federal laws come into play. The Gun-Free School Zones Act only honors permits issued by the same state where the school is located. Out-of-state permits are invalid. Florida law recognizes many other states' permits, but the federal government often does not. Driving through a school zone with a visible firearm, even with a valid permit, could result in federal charges. Federal law doesn't allow open carry in school zones at all, under any circumstances, even in your vehicle. Many responsible carriers assume their permit gives them immunity as long as they follow the rules, but federal law operates independently from state statutes, And even a minor mistake with a school nearby can become a federal case before you realize what's happening. Chapter 6. Third-party claims can trigger seizures. Most people assume that a confrontation with law enforcement is needed before their rights are challenged. But in many cases, a simple phone call or vague accusation from a stranger can result in firearm confiscation, even if you're legally carrying inside your own car. If a bystander reports a suspicious person with a gun, police are obligated to investigate. Officers can act preemptively if they feel public safety is at risk, even without actual evidence of a crime. In Florida, improperly displayed firearms or unclear behavior can be labeled as reckless exhibition. You may be disarmed temporarily or even arrested based solely on perception, not fact. What's terrifying is that you don't have to say or do anything wrong. If someone misunderstands your behavior, misinterprets body language, or simply feels nervous seeing a gun in your car, the situation can escalate quickly. And once police arrive, your legal firearm can turn into legal trouble. Chapter 7. Stand your ground doesn't always apply. Florida's stand your ground law is often misunderstood, especially when firearms are visible inside a vehicle. Many gun owners assume it provides full protection in self-defense situations, but that protection can vanish the moment law enforcement arrives or the situation is misinterpreted. Florida law allows deadly force only when you face an imminent unlawful threat. If your firearm is already in view and tensions rise, you may be seen as the aggressor. Open carry in a car, even if legal, complicates how self-defense is perceived in court. Police may interpret your display of a weapon as a threat, not protection. If an altercation occurs while your firearm is openly displayed, even just resting on your passenger seat, you might not be able to claim self-defense. The optics, witness statements, and timing all influence how the law views your actions. One wrong move, and stand your ground becomes you're under arrest. Chapter 8. Miscommunication during traffic stops. Traffic stops are already high-tension moments, especially for officers who don't know what to expect. If they spot a gun, visible or not, the encounter changes instantly. And how you communicate or fail to can mean the difference between a warning and a felony. Failing to declare your firearm if required creates mistrust and legal exposure. Rapid movements near a firearm, even to comply, may be seen as threatening. If the gun is partially exposed, you could be cited for improper exhibition or even arrested. Officers often call for backup when they see a firearm, escalating the encounter further. You may be fully within your rights, but if the officer feels unsure, it doesn't matter. They have wide discretion to detain, disarm, and charge based on how they perceive risk, and courts often side with the officer's reasonable belief, not your actual intention. Chapter 9. Parking lot pitfalls no one talks about. Carrying a visible firearm in your vehicle is one thing. Parking that vehicle in a lot where others can see it is another. This common mistake happens daily to gun owners leaving their firearm in plain view while they shop, eat, or work, and it leads to legal problems more often than you'd expect. Florida allows concealed storage, but visible guns invite accusations of negligence or threats. Many businesses ban firearms on their property, including in vehicles in their parking lots. If an employee or customer sees your gun and complains, security or police may be called. Some jurisdictions treat visible, unattended firearms as potential crimes. Even if your gun is legal and untouched, the wrong person noticing it can lead to charges, a trespass order, or even suspension of your permit. Some stores and employers even have posted policies that override your vehicle rights while on their land. Your parked car is not a loophole. It's a legal minefield. Chapter 10. One mistake can affect your gun rights forever. The biggest trap of all is thinking that a minor legal slip-up is no big deal. But with firearms, even a single charge, citation, or misunderstanding can lead to permanent consequences, including losing your right to carry, own, or transport a gun. A misdemeanor involving firearm misuse can disqualify you from future concealed carry licenses. Arrests, even without convictions, are logged and can affect background checks. Legal fees to clear up minor violations can reach thousands of dollars. Repeat accusations or violations can make you a target in future traffic stops. These laws are not designed to educate first-time violators, they are designed to penalize and restrict. If you end up in court, even with a good lawyer, the burden is on you to prove compliance. And once your record is marked, getting that clean slate back is nearly impossible. Know the law before you lose your rights. Open carry inside a vehicle might seem simple, but the legal landscape is anything but. Between federal restrictions, Florida-specific statutes, and private property conflicts, one mistake can lead to disaster. If you carry in your vehicle, you need to understand how your state, city, and even private businesses interpret that right. Ignorance is not a defense. and hesitation could be costly. If this video helped you learn something important, share it. Your freedom depends on it.